Thank you, Jeremy. Our next speaker, Robert Boyd from Cain, Lamarre, Montreal. We're pleased to welcome to our conference. And just so you know, Cain Lamarre they're a firm in Quebec with several offices, I believe, right throughout Quebec. Full service firm with a very strong labor and employment practice. And Cain Lamarre, along with our firm, belongs to the Work Law Network. Some of you may be familiar with that network. It's a network of employment and labor boutiques, firms for that focus on employment and labor law for employers. So if you ever need help outside of Ontario, let us know, because there's a good chance we have someone in our network in that jurisdiction who can help you out. And they're throughout the US, in Mexico, as well as Europe. And I believe we have a member in India as well. All right. Well, everything you wanted to know about Quebec employment law is on the menu next. Over to you, Robert.
Thank you, Lyndon. Great presentation, Jeremy. So I'm glad to be here. I'm with Cain Lamarre law firm, as you've just learned. So we are a full service law firm. I'm heading the employment law practice, and I've been collaborating on a few cases with Lyndon, Jeremy, Ryan. So nice to be here this morning. Speaking briefly about Quebec employment law this morning, and why you should care. First, if you have one employee in Quebec, that would be a good reason. But other than that, we have some very distinctive rules, and I think it's good to share with you. And I like to, when I draft contract or policies, to know what they are doing in some other jurisdictions. So you might find some inspiration in what I will tell you, particularly on harassment in the workplace policy in Quebec. We have a good experience because we have harassment recourse we had that for 20 years, and we have some very, very good policies that we had to put in place. So I'll talk this morning about those 5 key points that I want to share with you on Quebec employment laws. So terminating an employee without cause in Quebec, non-compete provision, harassment in the workplace, and sexual violence, sexual misconduct. When you can and cannot ask for a medical certificate for any leave of absence in Quebec. And the last and not the least, Charter of French Language. So there's a set of new obligations since 2022 if you have one employee in Quebec that you have to comply with. And termination provision. So it's great that we had Jeremy talking about the termination provision in Ontario. In Quebec, basically, we cannot contract out any entitlements, including the right to the common law notice. So we have in Quebec the equivalent of the common law notice, which is the reasonable notice in the Civil Code of Quebec. Basically, the rules to calculate the reasonable notice are very similar, and you can be in a situation where you have to pay a couple of months of severance of termination notice in addition to the statutory notice. The first rule is that there's no use of a termination provision in a contract. So we don't have the same case law and the same debate on whether you can contract out the right to the reasonable notice. You cannot contract out the right to the reasonable notice. So what it means is that even if you're using a very good termination provision draft where it's saying that we can terminate you without cause and provide you only with minimum statutory notice, the 2 weeks notice or 4 weeks notice, it will have no effect in Quebec. So you will still be in a situation where you might be exposed to paying the reasonable notice. So the question is, why having a termination provision in a contract in Quebec if you cannot contract out any entitlements? Basically, if you are putting in a contract, for example, for an executive that if we terminate you without cause, we're going to provide you with a 6 months indemnity or a 6 months notice. You're just providing a guarantee for the executive or the employee. So you're just setting the bar on what will be the minimal indemnity. But you might have to pay more. So the reasonable notice might be more than 6 months. So you're just giving the employee with a guarantee, and it might be part of the negotiation at hiring that an executive want to have a minimal indemnity for termination without cause. But even if you have set the bar at 6 months, you might be facing a claim for 12 months or 18 months if you have particular circumstances. Basically, like in Ontario, the reasonable notice or common law notice, you will be at risk when there's many years of service. The employee is over 55, 60 years old and can argue that it will take a long time to secure a similar job. So that will be the worst case. So I'm talking about the termination provision because I've seen a lot in Quebec of very good employment contract, but that had been based on Ontario law. So you use probably a good employment agreement prepared by Lyndon or Jeremy, and only change the last provision saying that the contract will be under Quebec laws. And you've used the same termination provision, and you have created the expectation to your managers that you can terminate an employee without cause and by providing only statutory notice, which is wrong. So we have to keep that in mind. And most of all, and that's a big red flag I'm bringing to your attention this morning, if your employee in Quebec has more than 2 years of service, there's a job protection. So you cannot terminate an employee after 2 years of service without just and sufficient cause. The exception to that is that you can terminate an employee for economic reasons. So you can eliminate a position. It's a just cause for termination. But it has to be a real economic reason, and they will look at how you choose the employee, the position that you want to eliminate. So for example, if you have 4 accountants and you have chosen to eliminate the position of the employee with the bad performance and the more seniority, it will raise question on whether you're just trying to terminate the employee without cause. And what it means is that after 2 years of service, if you want to terminate an employee for misconduct or misperformance, you have to build a very strong case, because he will be entitled to file a complaint with the Employment Standard Authority and ask to be reinstated in the same job position. And he will be provided with an attorney without fee from the Employment Standard Authority. And the case will probably be heard only in 18 to 24 months, maybe more, because of delays in Quebec. So you think you have a regular case of an employee, you're terminating the employee, he has a bad performance. You terminate the employment after 2 years of service. You think it will be an easy case. You offer him 2 months of severance in consideration of a release. He doesn't sign the release. He filed a complaint of unjust dismissal. You will try to settle the case in a mediation, but if you don't settle, there will be a court hearing in 18 months, 2 years, and you might have a decision in 2 years and a half that if you haven't demonstrated a just cause for termination and that you properly built the case, that you had sent notice prior to terminating the employee, you might be you have to take her back, and pay for the loss of pay since the termination. So we can see worst case scenario where you have to pay 2 to 3 years of salary, and you have to take back the employee in worst case. The good news is that the judge will reduce the indemnity from any earnings that the employee got during that period of time. But still, it's a very, very serious exposure that you can have. And That's why, unless you have a serious cause of termination, so case of fraud, stealing, violence in the workplace, that you can terminate for without building a case. In case of bad performance, employees not meeting the expectations, you have to properly build the case and notice, communicate in writing your expectations, give a delay to the employee to improve his conduct, and before reaching the termination. So, yeah. We're asking if it applies if you're using the temporary agency, employment agency, and you are hiring from an employee from the temporary agency. The court will look when there's a third party, an employment agency involved. The court will look at as who is the real employer. So, who has the authority on that employee? And if the temporary workers agency is only paying the wage, and in fact you are deciding to hire the employee or not, you are conducting the disciplinary meetings, so you have to be careful. So if you have to make sure that the employee remains de facto, in fact, the real employee of the temporary agency. So there's a risk. It doesn't mean that you can just call the agency and say we don't want that employee anymore. If in fact he is integrated into your company, is under your authority, you might have a situation where it will be recognized. You will be recognized as the real employer and facing a claim. Good question. So that's for termination in Quebec. So the advice is to properly build the case. And just to terminate on termination, I've seen often companies with head office or human resources manager in Ontario using termination letter and using language that we are terminating you without cause and providing you with a 6 months indemnity. Because we want to be fair and to offer a proper indemnity. But the fact that we are writing termination without cause, we will be stuck with that qualification. So if we don't have any settlement with the employee or if there's a claim, we just made an admission that it was a termination without cause, and we might have to take him back if he filed a claim of unjust dismissal and ask for his reinstatement. So again, it doesn't apply to elimination of position or for economic reasons. It applies to termination for misconduct or anything that the employee did. So that's the red flag for termination in Quebec. Non-compete provision. Again, if you have put in your termination letter that it's termination without cause, automatically, as per the Civil Code of Quebec, a non-compete is not enforceable in the event of a termination without cause. So you just lose the enforceability of your non-compete provision as from the moment that you are terminating without cause. Under the Civil Code of Quebec, the termination without cause includes a termination for economic reasons. So if you are eliminating the position, laying off, the non-compete won't apply. So basically, a non-compete will be enforceable first if you have proper language, but also if the employee resign or if you have terminating the employee for a just cause. So it's good to keep in mind. I think you have the same rule in common law, in some common law cases, that they will not apply a non-compete provision when you, at the same time, you have terminating the employee without cause. There are some cases also on that, but we have that specific rule in the Civil Code of Quebec. Harassment in the workplace, it is a big part of employment laws in Quebec. We had since 2004, employee can file complaint of harassment in the workplace with the Employment Standards Authority. So that authority will conduct an investigation There will be an hearing at some point. It's a big part of our practice in Quebec. That authority receives about 5,000 complaints a year. Often, an employee who is not happy with his termination will also file a complaint of harassment for strategic reason. So we still have to investigate. There is a new legislation in Quebec this year on harassment in the workplace. So we now have a mandatory policy that must be put in place since the month of September. And the legislator came with a very specific language that need to be in your harassment policy in Quebec. You need to indicate when you're providing training, how you're preventing harassment in the workplace, or that there's a new set of obligations that need to be in your policy. It's already enforced. So if you have employees in Quebec, you have the obligation to have a harassment policy. And since September, you had the obligation to update that policy and add new language. So I invite you to review your policy if you haven't done so in Quebec. And also, if you are in any other provinces this morning, I think it's a good idea to look at what kind of policy we have in Quebec. I think we have good practice in those policies, those mandatory policies, so it can be a source of inspiration for your policies in other provinces. So there's an obligation to provide harassment in the workplace training. With that new bill, we now have a definition of sexual violence in the workplace, which include any joke, any gesture of a sexual nature. And last thing, there's a new presumption. So employees, as in Ontario, we have the equivalent of the WSIB. So if you have a occupational disease or work accident, you can apply to get the compensation. And they have simplified with that new legislation the burden of proof of an employee, a victim of sexual violence in the workplace. And it says now an injury or illness of a worker is presumed to have occurred at work when it results from sexual violence committed by the employer, its managers, or a worker providing its services. So basically, if you are an employee and you say you had a sexual violence from an employee manager, that only fact will establish a presumption that it's related to work. So even if it happens in a bar on a Saturday night, the fact that the sexual violence come from a colleague or a manager, there's a presumption that it is linked to the workplace. They did that to simplify the burden of proof of an employee, so it can be easier to demonstrate that you have sexual violence in your workplace. So the second presumption is that the second provides that any illness that occurred within 3 months following the occurrence of a situation of sexual violence suffered by the worker at the workplace is presumed to be an occupational injury. So you had an event of sexual violence. 2 months later, you have a disease or a mental illness. There will be, if it happens within the 3 months of the sexual violence, it will be presumed to be linked to that sexual violence event. So again, they did that to offer greater protection to the victim of sexual violence, so it can be easier to demonstrate that you have suffered that in relation with the workplace. That's actually a new legislation also that will come into force on January 2025. So basically, the rule in Quebec, when you had an employee on a sick leave of absence, you could ask for a medical certificate. And now there's a new rule. No employer may request a medical certificate for the first 3 periods of absence, not exceeding 3 consecutive days, taking over a period of 2 months. So basically, there's 3 sequence of 3 days that you can take on a sick leave without the employer having any right to ask for a medical certificate. The reason they did that, the official reason is to reduce the administrative charge of the doctors in Quebec, saying you're spending too much time on providing certificate, medical certificate at the request of employers. So now for those three first leave of absence of 3 days, employers have no right to ask for a medical certificate. So it might be good for to reduce the workload of doctors, but it basically tell employees that you can take those leave 3 times a year, and your employer will have no right to ask for any justification. So basically, they're providing 9 days of sick leave without having to provide any justification. So that is the good news if you're on the employee side in Quebec. Charter of French language. We've heard a lot of things in the newspaper about the new legislation that came up in 2022. Actually, we have a Charter of French language we had for several decades. What happened in 2022 is that they have reinforced the protection of the French language on several sectors, including the workplace. Basically, what you need to know is that there's an obligation to provide French documents for any documents that are related to HR. So offers of employment, employment contracts, written communication. There's an exception for written communication. So you can communicate in English in your company if there's an agreement with if the employees agree. So basically, an employee could ask his manager to communicate with him in French. He will have the right to do that. In reality, as I always tell my clients, there's a lot of companies in Quebec where employees are only speaking English. So the issue will come when there's an employee asking for French, for French communication. He has the right to work in French. So the basic rule is that you have the right to work in French if you want to work in French in Quebec. And regarding employment contracts, one big red flag is that if you're not providing a French version of the employment agreement at hiring, the English version that you sign with your employee won't be enforceable. So it's a matter of enforceability. Keep that in mind. It doesn't apply if you have signed employment in English before 2022. The employee had 1 year to ask for a translation if he wanted. So it doesn't apply to the past. But you are an employee in Quebec. You are a sales rep. He will work only in English because he will be. For example, I have clients. They hire someone in Quebec, but he will be working only for clients in the US, only in English. So, and he only speaks English, and he doesn't want a French version of the contract. He doesn't care. You still have to provide a French version to assure the enforceability of the contract. So it's a good couple of bucks you can invest to make sure that you have an enforceable contract. The only exception to that rule is that it applies to contract that are not, they call that in a civil law contract of adhesion. So basically, if it's a contract that is negotiated between parties on the same level of bargaining power, that the employee had a real opportunity to negotiate the provision of the contract, then you can have a contract only in English. But in most of the time, you should consider that your contract is not is a contract of adhesion. It means that a contract that is imposed, that most of the provisions are imposed by the employer, and in those cases, you need to provide a French version. And there's a gray zone to know if it's a contract that was freely negotiated. And my recommendation is to do not take any chance. Provide the French version, so you won't have any debate on the enforceability. You can have a French version of a contract for $300-400. I mean, and it's the best investment you can do to make sure you have any possibility. Think about a situation where you will have a non-compete provision only draft in English, and in 5 years you have a litigation employees leaving for a competitor, and you are not provided that French version. You can be in trouble. Yeah. Yeah. So if the contract were signed only in English before that new legislation came into force in 2022, the employee had with those English contract had 1 year, I think, until June 2023 to ask for a French translation. If they didn't ask formally for that translation, you're good. You go on with only the English version for the anything that was signed before 2022. So, yeah, so you don't have to translate those contracts. So that it raised some issues when you have companies in Quebec with employees working with clients outside of Quebec that doesn't need to speak French. So you still have to provide those French documents. The other thing with the Charter of French Language is when you are asking a candidate or an employee to speak English or another language than French as a job requirement. You have the obligation now, since 2022, to justify why you are asking for another language than French. So basically, an employer is prohibited from requiring a person, that includes a candidate to a position, in order for the person to be able to keep a position or to obtain a position, in particular recruitment, hiring, transfer, or promotion, to have knowledge or a specific level of knowledge of a language other than the official language, unless the nature of the duties requires such knowledge. Even in the later case, so even if it requires the knowledge of English, the employer shall first take all reasonable means to avoid imposing such a requirement. An employer requiring a knowledge or a specific level of knowledge of a language other than the official language, French, must also publish an offer when you publish the offer for a position, must indicate in the offer the reasons that justify the requirement. So basically, you have to justify why you are asking as a job requirement the knowledge of another language, and you have to put it in your offer position when you have job post exact on your website for a position in Quebec. If you are requesting the knowledge of English, you have to add a little paragraph saying we are asking the knowledge of English because you will have to work with English-speaking employees, for example. So you have to add that to your job post. Now, the issue that we have is that before 2022, we had to demonstrate that the knowledge of another language was necessary for the job position. The new legislation is the last sentence. So even if it's necessary for the job position, the employer shall take all reasonable means to avoid imposing such a requirement. And what it means to take all reasonable means is set in the Charter of French Language. There's 3 conditions that you must meet. An employer is deemed not to have taken all reasonable means to avoid requiring knowledge of a language other than French if he omits to assess the actual language needs associated with the duties to be performed. So you're asking for the knowledge of English. You have to conduct an assessment. So you have to ask yourself why I'm asking for that position, the knowledge of English, and if possible, leave a trace. So you have to conduct a specific analysis. It doesn't mean to be a master thesis, but you have to have some justification and demonstrate that you have conduct that assessment. That first criteria is to make sure that employers are not just automatically asking for English. So you have to ask yourself if it's really necessary. The second rule, you have to make sure that the language knowledge already required from other staff members was insufficient for the performance of those duties. So you have to look internally to your position and ask yourself as a company, do I have employees that could meet my need to deal with my English speaking clients? If I do, I should not be requesting for new hiring the knowledge of English or another language. And the third criteria is you have to restrict as much as possible the number of positions involving duties whose performance requires knowledge or a specific level of knowledge of a language. So restrict as much as possible. So we don't know exactly what it means. It's a new set of obligations that will have to be interpreted by courts in Quebec. But just so you remember, what is new is that you now have a process to follow to justify the job requirement, as a job requirement, the knowledge of another language than French. It has to be put in perspective because there's a lot of employees working only in English in Quebec. It's still a business reality. So what that new law brings is an obligation for the employer to follow a process and to justify those requirements. So good to keep in mind. So I don't know where we are with the time, but thank you very much, and thank you for the invitation.
Well, thank you, Robert. That was very informative. Interesting to see some of the similarities, like workplace violence and harassment, but also some of the big differences between Quebec and Ontario, such as termination clauses and employment contracts. I think if there's one thing you take away from Robert's presentation, it's don't assume what you do in Ontario will work in Quebec, right? And for those of you who have worked with me and asked me Quebec employment law questions, I always then refer you to Robert because, yeah, even for an employment lawyer, I don't want to be taking my chances with complying with Quebec law. It's a very different jurisdiction.